Good evening, everybody. We're going to start in a minute. Just lower the camera. Oh, there I am. Right, so we'll just start in a minute. There's 2 minutes according to my two screens left. So I'm not going to steal anybody's time. I'm assuming everybody can hear me because there's a deathly quiet from my side, but I'm hearing nothing, absolutely nothing. Okay, hopefully that's better. Okay, the recording has started. Thank you, Malala Claudi. Appreciate that. So if anybody can just quickly say hello so that I can know you there, that would be great.
Hello.
Okay.
Hi, Marika.
Thank you very much. Good evening, everybody. There are some people that I can now hear, so I don't feel like I'm trapped in a suitcase or something, because it's so quiet. Okay, so guys, just before we start, a couple of things. The hi Morocco Joseph. I see you've said hi on the chat. I've uploaded the pre-assessment. Today was a bit hectic. We had almost 4 hours without any power here, irrespective of the fact that we do have a generator that feeds us. That also didn't work for today. So we lost about 4 hours of what was part of our planning, etc. So I still have to upload your memo for that. Then those of you who want to already start working on your assignment, I've uploaded the first assignment, and you'll see the due date if you go onto eLeader. Simone or Simone, I think everybody else is okay, because I did put mine up, and I know I do look like a space cadet, but this is voice cancelling, so this works for me. Unless it's summertime, then we really are in trouble with the heat. So as I said, um, just on the point of your assignments that you may want to work on already, you can go to eLeader, check for the first assignment. It's due in August. You can just have a look at that and start preparing whatever you can, and then we can take it from there as we go along. As you guys know, in the first 3 lectures, we are now on lecture number 4. Lecture 4 for this course. In the first lecture, general concepts was done, and then in the second lecture, I made sure that you could visualize the concepts by showing the actual examples, which are also on eLeader under the different chapters. If you are still looking for your manual, and there are some of you are still looking for the studying material, then go on to eLeader. The manual is on eLeader, so you can download it there as well. I also have, for the majority of the chapters, as I've said, I've uploaded examples, I've uploaded additional notes, etc., 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 to assist you. And where the chapters overlap, for instance, from chapter 3 actually onward, almost up to chapter 7, I think, that actually overlaps all into the Form E. And it was for that reason that I sent you the PowerPoint that basically breaks down and give you the different law and I'm not really saying law, what I'm saying is the different sections and regulations in the Deeds Registry Act, so that you know where we find the information for each one of those aspects. And also one of the things that we wanted to test right from the beginning is if you can understand in that pre-assessment questionnaire that we sent out, we tried to assess whether you have read some of the material already after the first lecture, and also to see if you can understand where we insert which detail. Now, in my experience, you can't really start with Form E without first drawing a power of attorney. Now, the problem with this is in the study guide. In the study guide, you will find that the power of attorney is only dealt with in Chapter 9. In Chapter 9 of the study guide, that's where we find the discussion of the power of attorney. Now, just to tell you that what we've done is we've looked at the sale agreements. We've spoken a bit of law. We've touched on a lot of the aspects of the sale agreement, because the majority of your transactions that you deal with are going to be sale agreements. So simple sale causa. It's a private treaty, basically, that we refer to. And then the rest of the work normally that comes across your desk in the average practice is either estate transfers or, as I said, plain and simple sale agreements. So obviously, because that is the case, we generalize into Form E, and first look at the sale agreement and the law behind it, because you can't really look at the sale agreement or prepare a sale agreement without knowing the aspects that I touched on, such as donations tax and capital gains tax and all of those kinds of things, if you can recall that. So please go through your sale agreement very well. The example that's there, the aspects that's pointed out, some of the clauses may be required to be drawn. And as we go along, and we deal with transfer duty and VAT, I've said before, we will look at each and every one of the separate kind of clauses that you have in your sale agreement, which you should have there. If we're dealing with for instance, a development, what kind of clauses normally do we insert in the development contract, because we don't want to be tied into something that's never approved, etc. So that's where our reversionary rights, our resolutive condition, those kinds of things comes in. And as we continue now in the course to sectional title, we will revisit all of those aspects and make sure that you also can now draw or refer back to those sections that we refer to. Is somebody trying to attract my attention? Let me just put the chat window on. Simona or Simono or Shimon, have you now, are you sorted yourself out? Okay, great. Okay. So as I said, I sent you out that PowerPoint. Now, before we start on that PowerPoint, I first want to go through the actual the manual, starting on chapter 3. Okay, so I'm going to pull that quickly over to the window that you can see, and I'm just going to scroll down to chapter 3, so that we can just look at generally quickly at what the manual says, because there's absolutely no function for me to sit and read this to you. That is something that you do on your own. Okay, I'm almost there. Okay, right. So just going to increase this for you so that you can see this properly, right? So, as you can see, this is our Form E that we basically deal with in general. We basically said that we normally deal with this with our deed of sale, as we've said. We can also deal with this, as I said to you, there's basically four important forms, and that is the Form E, which I said to you, always remember that in your head as everything that isn't Form G, H, and F. I'm not going to hammer on that. I'm just going to remind you that Form G is a transfer from government, H is a High Court order, and then F is the partitions. Okay, that's the partitions where we partition land. So those have their own form. So we know that if it doesn't fall in any of those or within the ambit of those sections, then we basically and that form, then we basically always use Form E. And all we do is we need to know how to word a causa then, because that's what's different, and the citation of the parties. Okay. So basically, what we've said here is that it's a will, it's a donation, it's a divorce order. Those are the things that we basically deal with in Form E, where the executor passes transfer, the seller is the transferor, where we have a rectification transfer, for instance. All of those kinds of things, those causa that we are going to be sending you a voice note on, so it's easier for you to learn. And just before everybody asks again, because I'm only dealing with Form E now, the voice notes for citations of party, causa, and parties and vesting clauses will only be sent to you from tomorrow. Okay. I haven't sent all of them out, and there's only one recording on the resources at the moment. Okay. So if you look at chapter 3, you're also going to see that we say there that the standard Form E has these clauses. Okay, the preparation clause. Okay, after you've done that pre-assessment, you now understand that there's a reason why I asked the question, who signs the power of attorney? Okay, who may sign a power of a preparation clause? Okay. And there's a different application in Section 15 and Regulation 44 onward that deals with the power of attorney's preparation clause as opposed to the deed of transfer. Okay. And then that prep clause, very important, all of the law relating to that. We're going to stand still on that just as when we go through the presentation. The heading of the title deed, the first thing that we have to always remember is that preparation clause in the title deed. Halfway down the page, heading. What is it? Is it a deed of title? Is it so in other words, is it a deed of transfer? Or is it, for instance, a notarial deed of cession? That's now notarial work. Okay, so whatever we are dealing with, that would be our heading. Our preamble, that is where we find the appearer that appears in front of the registrar. He appears in terms of the power of attorney. And in that preamble, we refer to the power of attorney that was granted by the transferor to the appearer, the conveyancer, right? And then we go on to the causa, the reason for our transfer. Then the vesting clause, who appears in the vesting clause. The vesting clause basically is the transferee, the person who receives. Okay. Now, as you see here, you are going to see that there's no mention here of between the vesting clause and the property clause. There's no mention here of the question that I asked about the succession clause. Okay, it's because I said to you, a lot of people don't even consider that as a separate clause. Okay, but for clarity's sake, I've inserted that as if though it's a clause. So you can write in your notes, just there between vesting and property, you can insert another heading that says succession clause. Okay, then our property clause, that runs up to the extending clause. That tells us what the history of the property was. As I said to you, did it come from a general plan? Did it come from a subdivision? where is the source? How was it created? Because every parcel of land is surveyed, indicated on either a general plan or a diagram, and that is recorded in the Surveyor General's office, approved by the Surveyor General's office, and that is how we receive our find our property. Then, and that is you can write next to it already, Form TT and Form UU. A lot of people battle with Form TT and Form UU, so we really attempt to make it easy for you. Conditions clause, okay, those are all of our conditions of title. Divesting clause, that's where when we divest, we basically take away the rights, and then we vest it in the new owner. So we divest the old owner and we vest it now in the new owner. Then we have the consideration clause, okay, and that is now telling us what is the value of the property, because that has to tie in with our transfer duty receipt for purposes of transfer duty and the receiver. And then the execution clause, that is the registrar signature and the area, the registry in which you are going to be registering the property. So as I said to you, if we deal with anything, the important thing here is if we are dealing with a power of attorney, we don't leave the first half of the page, you'll see it now open. But if we do deal with a certificate, a CRT, a CCT, or a deed of transfer, then the first part of the paper is, of your paper, or from the preparation clause, right down middle, there we start again. Okay, now in the exam, please don't listen to me very carefully. Please don't sit there and go and measure 4 centimeter binding margins. Okay, you don't have to do that, really. Don't sit and waste your time by going, I have to have a 4 centimeter binding margin. Okay. Do you understand what the 4 centimeter binding margin is? Anybody that wants to interact? Okay, the binding margin is only on the left-hand side, because that's considered the binding margin. Okay, so it's on your left-hand side, there's a 4 centimeter binding margin. Please don't sit in the exam and go, I've got to go and measure that out. Don't waste your time. Right? So it's only on the left-hand side, and then each page must be numbered. Typing must appear on the side of the page only, one side. So this is where we're a bit different from litigation, because litigation, we print everything on all sides to save paper. But in conveyancing, in litigation, we do that normally to save the paper. But in conveyancing, if you get a document back from a client and it's printed on both sides or signed with anything but a black pen, you immediately send it back and say, quickly sign it again. And remember that it's got to be on both parts. It has to be printed only on one side. Then obviously, if I am going to have a blank space, I have to draw a straight down line through it. And then obviously my paper must be a good quality, and it must be my typing must be of a font that is clear and legible. And obviously, the documents must be signed in black, as I've just said to you. Okay, no, you will find that if you ever receive documents or a power of attorney that was signed under an apostille, for instance, in London, they send them back in blue pen if you don't properly explain it to them to the parties. And then if you try and lodge that at the deeds office, they reject it and they say, our scanners don't pick up blue, so you've got to do something about it, get it signed again. It's got to be in black only, black ink only. So there you can see where we start with the preparation clause. Okay, and as I said to you, there's certain requirements in this regard, and the most important one is Section 15 of the DRA. Okay, and there we see that the deed of transfer and the mortgage bond has to be contain a preparation clause. Very important. Everything that we register in the deeds office is obviously to be prepared, have a preparation clause and signed by our conveyancer. But for those exceptions, as I said, for the power of attorney, headings and title deed numbers, obviously. You describe them as the deed of transfer number, whatever the deed of transfer number is. That is normally stamped in on your holding deed. Then your preamble, you can just remember that my preamble is where I find the details of the appearer, which deeds office I'm going to be in, who, where, and on what date the power of attorney was granted, and to whom. Okay, and then who signed, who appears in that? The transferor. Okay, chapter 4. Then the recital, that is our cause, chapter 5, we'll deal with that. Vesting clause, that's who we receive it, that's a transferee's description. And then the property clause and the extending clause. Okay, and I've said to you property clause up to the point where we say in extent 1,000 square meters. Then we go on to form TT and form UU for the extending clauses. Okay, and this we find in chapter 7. And then the condition clauses, a lot of attention has to be, I want you to mark that if you can with a red pen. This is very important. Condition clauses, how to plot a condition in order to bring it forward in a title deed. This normally relates to servitudes that either are open servitudes or they are already registered and therefore has a servitude number and obviously a notarial deed number in certain circumstances, and there might be a servitude diagram. Okay. So now, if we know that this chapter 3 is now our general form E that we normally use, then we can look at chapter 4. Is there any questions on chapter 3? Can we continue? Yes, no, I don't know. I'm not here. I'm just low. Let me just see what the notes are. Okay, wait. Let me just go back. I didn't see all your questions. Can you repeat the margin part, especially on the numbering part? Okay, the margin is the binding margin. It's only on the left-hand side, 4 centimeter. And I said to you in the exam, don't waste your time. Don't go and measure it out. Just start writing in your book. Okay, and then the numbering part, every page has to be numbered. Following the first page, because your first page is the prep clause at the top, way down the page heading, go into preamble, and then second page, number 2. Okay, at the top, in the middle, or we normally put them at the top. You have to number them. Okay, so is that clear enough up to that point? And then I got yes. Alan Jackson, the CRC applicable is 4 of 2009, I think. Or I'll just have to look, but I posted it in anyway in the resources. It sets all of this out, every single thing. Okay, so you can find it there. But you don't have to really spend that much time on it. I want you to rather go and sit and draft and sit and draft power of attorney. From the power of attorney, continue on into my my draft deed. Now the thing is I'm going to give you a couple of things to draft for me. Okay. And I'm not going to mark them because I can't give you each an individual feedback. And I mean, it's impossible. So what I want you to do, and this is where the self um, reliance comes into to being. Okay, is you do the work. Then when I go through the answer, then you know whether you did it right or wrong. Okay. So I think you will appreciate that I do respond to everybody. Everybody I can respond to. There's one of the candidates that's not on any WhatsApp. So I make sure that I send her separately the information, etc. So so guys, just work with me on this. Go and do the little bit of the work, etc. I'll look for the exact CRC, and then I'll just upload it onto WhatsApp and send it out, and then I'll just refer to you on under which chapter I've posted it on eLeader. Okay, right. So, uh, any questions at this point? Right now, before I go into this, I want to show you a deed. Is somebody talking to me?
Yes.
Yes, who's talking to me?
Sarah.
Yes, Sarah?
I just want to know, under the heading, do we
Yes.
put the old title or the new title deed?
Your heading is only going to say deed of transfer. Okay,
Yes.
that's it. Okay, the deed of transfer number is stamped in on. You're going to see how it looks just now on on registration.
Oh, okay.
Okay, I'm going to show you that now so that you can visualize it. Um, Arthur Mashila, you said on lead notes, did they forget the insert the accession clause? I said to you guys that a lot of people don't even, I mean, all of my 21 years in practice, um, I never really considered it as a separate clause, but as it's 10 years, 12 years ago when I started working with John Christie, he called it the succession clause. And I thought, well, that's nifty to remember it because property goes into your estate. So always remember to double check your extending clause, your succession clause. And from there on, I've started to also refer to it as the vesting clause. And because there's three different kinds of them, when I lecture, it helps you guys um, to also put that practice of it's going into the estate, etc. And how do I cite the different vesting clause for your drafting and not vesting succession clause, like a succession clause. Okay, so they didn't forget it. Some people refer to it as vesting clauses separately. I never used to. And then I just adopted the person I started lecturing with, John Christie, his manner, and it just made sense to me to when I explain things. Okay. Mondi is asking when we drafting any document has to be word by word as per the book or as long as it makes sense. Guys, um, uh, uh, pleasure, Arthur. Guys, I'm getting to that. There's forms or there's documents that you're going to deal with that has no form prescribed to it. In those, as long as you, and I will point them out to you, there's only a couple of them. It is applications and it's powers of attorney. So powers of attorney and applications. Okay, right. We start with those two because those are the easy ones. Okay, those two, they don't have any form of prescribed form. Okay, so there it's your own drafting, and this is why I always say is if you are in a working with conveyances at the moment or in a practice where there's also conveyances, please don't go and take the E4, what's the other software out there? E4, Ghost Convey, Lexis Convey. and there's another one that the guys in Pretoria like to use, Legal Suite. Legal Suite. Please don't go and take that power of attorney, because it has a bottom paragraph in the power of attorney that's like going to take you, at least if you write big, it's going to take you a page to fill out. I'm going to tell you I'm going to shorten it. This, that's all you need to allege. In that last paragraph, it's all about the citation and then the 3 things that you have to say at the bottom. Okay, so forms, you follow the form in the book. Okay, you do not deviate. If there's something to deviate, I will point it out. For instance, you can there's a margin of uh, um, uh, differentiation in certain causa that can be allowed, but the rest of the form has to follow exactly Form E. Okay, Form F, Form G, Form H, etc. So if there's a form prescribed, you follow that form. If there's no form prescribed, then it's freehand drafting. It's drafting. It's drafting skill and drafting way. Okay, so it's your personal uh, touch to drafting. So what I want to quickly just show you is a deed so that you can see what it looks like when it goes into why we have these pages open, etc. So give me one moment to just find it quickly. Those are in it, by the way, they are posted on uh, on eLeader as well. You just have to go through the different chapters and you're going to find them there. They are there. So I just want to quickly go into my lead, all the years of examples. Okay, I'm going to pull this one in for you. Okay, this one was registered. Okay, this is the lodging jacket. This is the lodging jacket. Okay, there was 2 linking matters. We spoke about linking matters. It's from the first chapter. Go and read it again. Okay, then this. Look, this is a deed of transfer. When you prepare it, Sarah, when you prepare it, do you see that there? That is the heading. So look from here, preparation clause, right down to here. You can clearly see, let me just increase this for you in size. Okay, don't go left. Okay, well, everybody can see it still. So if I look at this from the perspective of this is now an A4 page, we start at the right hand top corner. We do the preparation clause. Prepared by me, who? The conveyancer that signs it. Full names. What do we add here? We add the LPCM number. The Legal Practice Council member number. LPCM number comes below this. That was introduced, I think, a year and a half ago or something like that. Fairly recent. Then if you look at this and you measure it by eye, you're going to see halfway down the page, I have my heading. There's my heading. Okay. Now, it's only the heading that you insert. You do not refer to this. Why? Can you see that that's a stamp? That stamp is stamped in by the deeds office because once I registered this draft deed, this started out as a draft deed, not a holding deed. This now becomes a holding deed. This started out in 2017 as a draft deed. Okay. And here you can say C&A Friedlander Incorporated. They prepared it. Okay. So that was the company in Cape Town that started, that prepared this draft deed. Okay. The conveyancer is Stephen John Borwick. Okay. So we leave that first page over, the first half of the page open. Why? Exactly for this purpose. Can you see that there's stamps here? So the registrar is going to come, and if it's a cash sale, there won't be a mortgaged stamp. There won't be that. But for every transaction, the registrar comes and he stamps in the purchase price, and he stamps, he basically fixes one stamp for registration purposes, and he writes in the purchase price and the deeds office registration fee. Okay, the deeds office registration fee. Now, if this is mortgaged, then the registrar stamps in this space the stamp that says mortgage. Now, if this bond is eventually cancelled, then he stamps he puts a stamp here that says BC cancelled, and then then appears a BC number. Here's a bond registered, and that's the bond registration number B32792 of 2017, mortgaged. If it's now cancelled, say in 2018, then there's going to be a square, a more square stamp that says BC, bond cancelled, and its date, and it's going to have a BC number. And all of these, you can see these are stamps. So that is why you do not say deed of transfer and put the title deed number next to it when it's your draft deed. Because the deeds office, if there's no rejection note, is going to stamp it in. And then in the future, we're going to use this as our holding title number. And then we go on to, this is the part, the preamble. Here, this is 100% the form of Form E. Be it hereby made known, appeared before me, Registrar of Deeds at Cape Town, the said appearer being duly authorized thereto by power of attorney, which power of attorney was signed at where? Cape Town on the 17th of 2017, and it was granted to him, who him? Who him? The appearer. Okay, there was a power of attorney for the appearer. Dominique Volhitter appears in the power of attorney. Can you now understand why I prefer to start with prepare your power of attorney? Because once you prepare that, you take that information and insert it here. You can't really understand how to prepare a draft deed if you don't understand how to prepare a power of attorney. Therefore, I would switch the chapters to put power of attorney before draft deed, or Form E for that matter, and all the other aspects of it. So here you can see this first page has no number on it, but the second one is numbered. Okay, now you don't have to write page 2 as long as you see it is identified 2. Okay, so this was prepared using Ghost Convey software, so that's why it looks like this. Okay, right. So this is the causa of the standard sale. Look, truly and legally sold by private treaty. Okay, and the date. Then who sold it? It's the who received it? The transferee is the purchaser, and there's the succession clause. Look, this is a company, so it's the successors in title. I said to you, remember title? I hold the title of director. So that's how we always remember. If we have a company, it's going to say its successors in title or assigns in full and fee property. That basically tells us that this is not leasehold. Okay. And then we go on to the property description. Then we have that extending clause. And then comes our conditions. And that is sorry, my mouse has died on me. And then that's where subject, that means from subject, it follows my conditions onward. Okay, and now that's our conditions. And look, every page is numbered. Okay, every page is numbered. Every page is numbered. Okay, and then when we get to the last page, look, there's that. You see what I said to you? Every part that is not typed in, we line through perfectly straight. Not like in pleadings and things, we go all across it. Nope, we go perfectly straight. And then this is my divesting clause. Wherefore the said appearer renouncing all rights. Why renouncing? Because after this transfer is done, this is no longer the owner. So we divest him, renounce all rights, we divest him, okay? And then now, see, there's the disentitlement, and now this company is now the owner. Its successors in title, assigns, etc., henceforth shall be entitled to it. This is your consideration clause, 18 million rand. Okay, in witness whereof execution. Okay, registrar of deeds signs, and who signs there? Who do you think signs there? The guy that appeared in the deeds office to do this. Who? Mr. Volhitter. Or I think that's a woman, sorry. maybe Dominique Bullletter. Okay, right. So are there any questions? Can you now visualize this? Let's start off by asking that question. Can you visualize this? So now from here, this is your power of attorney. From here, that's your transfer duty receipt. That's your clearance. Okay. From here, we can now look at that presentation that I sent to you. I can hear somebody's trying to talk to me. Let me quickly check any questions. Oh, zoom in a bit. Let me zoom in a bit. You see, if I zoom in, it goes to the side. But
but you can send to that. Sorry, Marika, it's Alan. Can you hear me?
Yes, yes.
I just want to check with you with regard to the succession clause that you just showed now. Is that that's not in terms of the wills and intestate estates? That's just succession in terms of the Companies Act. Yeah. Okay.
Remember, I said there's three of them: natural persons, companies, and then the trust. And I said to you, this one will, because it's a company, will always say successors in title. The trust will always say successors in office, because nomino officio.
Okay.
I hold my position in office only. So this is unique to conveyancing. There's a couple of things that's very unique to us, in the sense that because we are clever, we will never do an affidavit saying an adult male person, because we can read an ID number and know whether it's an adult and whether he's male or female. You know.
Yeah. I just the one thing that I want to just check with you, when I mentioned CRCs earlier on.
Yeah.
I've been doing obviously some homework.
Yes.
When you relate to these vesting clauses, etc., and if you look at the POA, they talk about various CRCs that have to be understood and well known.
Yes.
So that's why I'm referring back to the CRCs, because I think this is quite important that they also stipulate in the CRC how you must address or cite the names of the representatives, etc. So the one that you're talking about in reference to the Companies Act is CRC 28 of 2013.
28 of 2013. I'm going to post it on WhatsApp. And then the other one that's extremely important is it's 27 of 2013 and 28 of 2013. It's extreme. Those two are maybe two of the most important ones there are. Okay.
Sorry, and I want to just check. Yeah. So 27 refers to customary marriages, right?
Yes.
Okay, that I understand.
Customary marriages. 28 is companies. So I really didn't want to give you all of the resources before we start looking and understanding. But those I'm going to, when we break just now for a quick sip of water, I'm going to quickly post those two CRCs. And also, if you looked at my presentation carefully, you would see that I also refer in that presentation to a lot of the CRCs that are important. But not only that, I also reference the Act, which part says what do I have to do. So when they asked me the CRC, I thought you were talking about the format of a deed of transfer, because that is like a stupid one, like from long ago. We tell you what's important there, but I've uploaded previously on e-leader as well.
Yeah. Okay. I don't want to interrupt your lecture too much. I just want to understand, because when I read it, and I always look at all of these sections and regulations are always read in conjunction with the CRCs.
Yes.
So,
and that is very important, because I'm going to open this for you guys. Here is what Alan is talking about. Chief Registrar Circular 28 of 2013. It tells you exactly how to cite the companies. It tells you what the requirements are. there it tells you, because remember, we now have state-owned companies, we have ring-fence companies that has to be referred to as RF, ring-fence companies there. Are they incorporated in South Africa? Are they not? Are they incorporated outside of South Africa? State-owned companies there, SOC. So you need to know this CRC off by heart, and you do not get this in in any of the exams. You do not get any of this. Okay.
Mareka, just also to add to that, because when we talk about CRC 28 of 13, I think there's a very explicit understanding that we need to look at Regulation 18 at the same time.
Yes, yes.
Specifically for state-owned companies.
Yes, exactly. So that is why, as we go on, we look at citations of transferors in the preamble, and then we look at citations of transferees in the vesting clauses and the divesting clauses. And we have to keep them separate, because I can't just go and study, oh, okay, I'm going to do a company now. I'm just going to say ABC Pty Limited, registration number, whatever.
Understand.
Okay. Not because of my power of attorney, it's differently cited. If it's the transferor, in my power of attorney in the vesting clause, transferee is differently cited. In my deed of transfer, it's completely different in both from the power of attorney in both the preamble and in the vesting clause. And this is why I wanted to do powers of attorney together with the Form E. But guys, this is an extremely important one. 27 and 28 of 2013. We are at the moment, we are dealing with the Companies Act one, which is 28 of 2013. Okay, very, very important. This is always posted everywhere. Very important. I think somebody else is trying to, okay, wait, I just want to quickly see the question here. It's starting to make more sense. Okay, Roxanne, I'm very glad about that. The more I zoom in, guys, the more it goes to the one side, but I'll keep zooming in. And then Willem Shabalala says, in the draft deed, the conveyancer is Stephen, but the appearer is Dominique. Yes, your conveyancer that signs off the prep clause, okay, the preparation clause in terms of that person is seldomly the same person. In some companies, you are lucky that because you have maybe 10 different conveyancers that will appear on a date. Some companies has a separate conveyancer that just do the execution work for them. And especially now during COVID, to make it more relevant, the firms in Pietermaritzburg will 1 week only send one conveyancer. The next week, another conveyancer. And I mean, I'm talking now about the big companies like J. Leslie Smith, Stoll and Company. Those guys, they don't have one conveyancer, they have 10 or 20. So they take one for 1 week, or maybe one is sick or getting married, then that person, and that's, you stamp him in. And when you prepare your draft deed, I'm going to show you, you leave the appearer open, because that person who appears that morning when it's executed, he has a rubber stamp that quickly he stamps his name in. Because in terms of the power of attorney, all of them are included to appear in front of the registrar. But I'll explain that as we get to that. Somebody is saying, I did not understand the explanation you gave on what the successors in title mean. When we deal with a company, and the company is the transferee, Nangeni, Ganyeni, okay, whatever, you'll laugh at me later. So if I'm dealing with a company that's being vested, then my my succession clause will refer to its successors in title and assigned, nominees and assigns, okay. Title, because the directors holds position as a title, okay, in a company. They are the organs that act on behalf of the company. With the trust, you can't use the succession clause that says successors in title. You have to say successors in office, because a trustee acts nomina officio in his specific office as a trustee. He is fiduciary in nature. Okay, so that's the explanation. I hope that makes sense. Okay. The other one was Sarah's question regarding, but we've dealt with that. Okay. Ndanganeni. Okay. Yeah, you can laugh at me later. It's fine. I laugh at myself regularly. So please, this CRC, because we haven't really done citations, Alan was right to start preempting it. And when we were doing citations, I would pull this up and show you. The other one that I wanted to quickly just show you is this one. My mouse is dying on me for some reason. Nope, not that one. There. Oh, I think I saved it incorrectly. Interesting. Okay, let's go there. There we go. There we go. That is 27 of 2013. These are two of the most important CRCs you have to remember for citations. Okay, let me just zoom in again. And as we deal with citations, you're going to see this is the Registration of Customary Marriages Act. And then it tells us how do we cite under certain circumstances the parties. Okay, and this is now that case that I referred to you to. That's a 2021 decision that has basically now affected almost 400,000 married women that I showed you. That's very important to also read with this. Okay. But we'll get back to that case. Don't stress about it. I think Enoch is trying to attract my advocate, Enoch.
Good evening. When I see under the execution clause, there's a signature of appearer, there's a Q.
Yeah, quadque. So that would be in his under. You're talking about the last page. Yes, that's in his capacity as the appearer. So did you guys see that as RCR1 and RCR2 of this year? And the electronic deeds register that has to be kept now of every conveyancer that's been admitted and practicing. Now, when I was just, well, it was not even when I was just admitted. Yeah, it was actually when I did my first executions, and as I traveled from one province to the other, very early on, I remember I had to go and sign a register in front of the registrar in Johannesburg. Basically, so that they have a record of my signature, and also to make them aware of the fact that I am an admitted conveyancer. But that seems to have fallen out of use, I think, because whenever I talk to people, I ask them, did they sign the register? And they always go like, which register? So that electronic record that's now going to be part, it's to make sure that we don't have a person that's not even a conveyancer signing, appearing or signing a preparation clause. Okay, because we are authorized to sign these documents by virtue of the fact that we wrote the exam, we passed it, and we were admitted as a fit and proper person as a conveyancer.
Okay.
So that signature here is a Bolhutter. That's Bolhutter's signature, and that signature is different to the signature. Sorry, I'm probably making you dizzy. To the preparation, the preparer. Okay. Right.
What I wanted to understand is that Q dot Q. What does it stand for? Q dot Q.
Quadque.
What does it mean?
Now you're putting me on the spot here for my Latin. Quadque. What was it? He who or something, isn't it? I can't remember. That I can't remember. But you can remember, I'm sure.
No, I think I'm seeing it for the first time.
I think it's quite it's good question. I'll quickly look at my Latin phrases book. I still have it from 1992. Yes.
Okay, that's fine.
Okay. Anything else?
No, that's all from me.
Okay. Right. It is now half past 6. It's 6:30. So I'm going to grab a glass of water, and then I'm just going to quickly also pull up another slide that oh wait, there's another question. Chantal Reddy asking to be added. One of you helped very much last week to just quickly copy the link into the thingy to just allow somebody to click on the link and go to the WhatsApp group. So whoever that was, I'm sorry I forgot your name. It was a lady. So if anybody can just copy the link in for Chantal, otherwise you're going to have to WhatsApp me and I will add you and send you the link. Okay. Right. So guys, can we quickly take just 10 minutes? I just want to go and get tea and a sip of water. And I just want to pull up that one CRT, and then we can go on to the next phase of our lectures. Okay. Great. So we're back at, oh, wait. No, it's 5:02. We're back at 25:02. 25 minutes to 7. We start again. Thank you, Hazel. Oh, it was Hazel. Hazel did that last time. Yes. Thank you, Betsy Sai and Hazel for the link. Okay, guys, I'm going to quickly just switch my mic off so that Thanks, Lovey. Okay, it is now, no, it's still 2 minutes. Qualitate qua, capacity of, he who, capacity of. Thank you, QQ. I knew you knew. And I know you knew I knew that you knew.
No, I did not know. No, you know, I tried to Google. I couldn't get it initially. That's why I asked. But then when you say Latin, I went back and I said QQ Latin. Then that's what I got.
Oh, it's yeah, I said quaque. You. I know there was a quad somewhere in there.
Okay.
Thank you. Now you've reminded me of something as well. Thank you very much.
All right.
We have 1 minute still before I can formally speak.
Okay.
But I don't want to take anything away from anybody or prejudice anybody. I think just there it is, exactly 6:35 on my screen. So guys, the QQ advocate Ngobeni has actually checked it up and given us the actual proper word. Still, I'm right, he who, because it's about capacity. So he put it in the little box there. Arthur, I'm going to look at your, or in the text box there, I'm going to look at your question just now. I want to say something. For every single thing that we do in the deeds office, there are maybe 1, maybe 2, maybe 4, maybe 15 different registrar circulars, CRC specifically. I want to, I'm hoping, yeah, I think you can. This is my registrar circulars book. All of these yellow notes, stickies, okay, because they're color tagged, they only relate to applications in terms of section 4, subsection 1, subsection B of the Deeds Registry Act. So I had one of those exceptional matters that very few people has ever dealt with. So I started reading up on section 4.1b, Chief Registrar Circulars. And this was all that I came across. So what Alan mentioned a couple of minutes ago is extremely important. When we have a circular that's basically saying to us, we are dealing with company law and we're dealing with a part of company law, whether it's a specific section and how it affects the deeds registry, if it's a regulation in terms of a specific act, you, by virtue of the fact that it's taken up, it's contained in a chief registrar circular, you by implication have to know all the law that's related to that. So when I say Chief Registrar Circular 28 of 2030, you have to immediately know I've got all of the law that relates to that CRC, everything in my head, and that is extremely important. We have a bit of an interference on the line, but for instance, there is actually even a chief registrar circular that says, as I said to you, the font size. It says that circular says your font size in your deed of transfer cannot, when it starts out, cannot be smaller than 2 millimeters. It doesn't tell you what kind of font you need to use, but it tells you that if you are sending in a deed for registration, a draft deed, and for instance, that font that you used is smaller than 2 millimeters, the deed will be rejected. by the examiner. So that's how specific our work is. There was a period where I just didn't subscribe to any software, and I prepared everything by hand, and I literally had to go and make sure that I have the 4 centimeters, etc. And I thought, geez, you know, it was right at the beginning when I didn't really like conveyancing and all of that. And I thought, how pedantic can you be? Like, really give me a break, you know, because in court, you just shoot from the hip, and that's how it is, you know, especially with criminal work sometimes. So, but everything we do are contained in a circular. There's very little, if any, arguments you can have with an examiner or a registrar. We always laugh about that when we were fortunate enough to actually personally attend to Alan West's update every year on conveyancing developments. We used to laugh. They sit with Alan's book next to them. But when you take the book and you say, but the practical guide says this, then they say, but we don't follow that, you know. So you can never try and go and be clever and argue. You have CRCs, you've got the Act. And if you get a really difficult examiner, you can be penalized for very, very simple things. Okay, so from that point of view, I've never actually, because I've been doing this so long, not this, but conveyancing so long, I just assume that everybody would know. It's like, if you are talking about one part of legislation, then you are presumed, because that's why I keep on saying to you guys, that question that came on the group that said which chapters and which chapters. Guys, this is not that kind of law. You don't get chapters for a paper. You are supposed to know everything. This is why this is a challenge. And this is why so few people actually pass this, because there's no scope. The first time I did an exam prep lecture, which after that lecture I said to John, I will never do them again, because they all asked me for scope. And I said, what does scope even mean? Because I'm from a university era where there was no scope. And I said to the attendees, what's scope? What does that even mean? You just keep saying to me, scope, scope. I said, to me, a scope is an adult magazine from the 1980s. I think most men said they bought it for the good articles in it. That's scope. That's not law. There is no scope in conveyancing. There's only everything. Okay, so important. So Alan's actually reminded me to always say that. I thought some of the men would find it funny, and the women, yeah, especially those from litigation background. Yeah, I remember some stories, but anyway, right. So I've expanded. Remember, I said to you, I think that thing about how exactly all the requirements for the deed and the procedures, etc., was somewhere in the 2009s. Well, I was right. It's Circular Chief Registrar Circular 2 of 2009, and this basically tells you capturing and scanning of documents registered in the Deeds Office. And in this, you find the parts that says how big, which regulations are affected by this, which codes are used. Also, look, the sectional bond, there, SBC, BCG, proclamations, we'll get to all of those, the transfers, the grants, etc. We'll get to those, all of those, the normal bonds, B, SB, so on, servitude, all of these abbreviations, you need to know them. You need to know where to use them, anti-nuptial codes, etc. And it also goes on to say generally legible, and a couple of other matters. Look, here again, that section 41B comes up a lot, because you have to amend, a lot of times you have to amend documents that were drafted in accordance with previous guidelines in terms of the CRC, but then the CRC comes out and it changes the process, then when I do my draft deed, I might have to first amend the holding deed before I can proceed to prepare and register the draft deed. So all of that falls under CRC 2 of 2009. So go and have a look at that after the lecture as well, and then we can continue on with the slide show that I've, no slide show, so it's a PowerPoint that I presented, prepared. Okay, I'll point out if anything changed. Now, remember I said that CRC 1 and 2 of 2021, there are, for your purposes, not a lot have changed. Okay, it's not earth-shattering things. One of the forms, Form V, we get to that later. Okay, that form has been amended. Okay, so it's our job to show you how it was amended and what the new form is, and we will do that. And then there's specific regulation 6811 changes that came into effect, but by and large, it's not earth-shattering changes at all. I just realized I forgot to upload during my quick tea break the 2 CRCs, but I will do that to the WhatsApp group. Okay, right. So you can see the PowerPoint. Okay, you can see the PowerPoint here, and we basically are dealing with Form E here, as I said before. So Form E, you'll remember as everything. Where do we find this? We find it in section 20. What does section 20 say? It says, okay, it says to you that at the end of the day, there's a form and a manner, and that is prescribed for the execution of a deed of transfer. And that whole section you need to know very well, because it says it shall, listen carefully. Those of you who can still recall the interpretation of statutes lecture, it shall, there's not a it may, and that's why I said to you as we're getting to it, if you have a Form E prescribed to you, then you have no choice, you have to follow that form. You cannot deviate from its wording. Okay, deviate from it and you'll be rejected. Okay. Yeah, shall, must, you have no choice, no may. Okay, right. So specifically, shall be prepared in the form prescribed by law or by regulation, and save as in the act, this act or any other act, act or any law provided or ordered by a court, including a court with the necessary jurisdiction for purposes of the Deeds Registry Act. That court is always the High Court. When we read about a court, it's the High Court. Okay. It refers to jurisdiction established in terms of Magistrates Courts Act, etc. Your court is the High Court. Remember that. Forget about that insertion, because that is for purposes of your regional courts, High Court. Okay. Deeds of transfer executed in front of the registrar shall be executed in the presence of the registrar by the owner of the land. So interesting. So the owner of the land can actually go and stand in front of the registrar himself. I've never heard of any owner of land that shows up and go and execute his deed. Never. Okay. But the Section 20 actually says in the presence of the registrar, either the owner of the land, okay, described then, or a conveyancer authorized by power of attorney to act on behalf of the owner. Okay. So he's the one that executes. Executes means I perform an act of execution by my signature. Okay. And then, so in other words, I execute, and that's a very important thing to understand from the concepts, the difference between execution and attestation. When do I execute? When does when do the registrar execute? Okay. So specifically, a deed of transfer is executed by either the owner or by the conveyancer that was authorized in terms of the power of the attorney to pass transfer, okay, in front of the registrar. And what does the registrar do? Does he execute? No, he attests to the fact that an authorized person came and executed, signed this in front of me, and by signing that, everything in that deed has the lawful authority of having the effect of passing transfer of ownership. And this is where things are so important to remember, because when we get to servitudes in the future, we're going to see the differences here, okay? Because we have ownership, which is the most perfect and complete right, okay, limited only by the Constitution, etc., and common law, etc., etc. We're not going to talk about that. And, you know, if you buy into sectional title and homeowners association, limited by their rules under certain circumstances, etc., we're not going to talk about that now. So everything else is a limited real right, okay? Everything else is limited if I don't pass transfer, okay? So ownership is my complete real right. But if I limit it, so in other words, I'm registering a long lease, I'm registering a usufruct, habitatio, a usus, a right of way, any of those, then it's a limited right, whether it's personal or a predial. And that's why this is so important to be able to distinguish between the differences between predial and personal, real, and real and personal. Okay, so very important, and we're going to go into depth. I just touched on it, but it's going to be gone into depth when we deal with servitudes. Okay, right. So important there is our section 20 that says there is a form that's prescribed. There's a form that's prescribed for it, and it's prescribed in terms of section 20, and then I have to put next to me the regulation. I've got to put next to me the regulation 82. So again, just by the fact that I've referenced regulation 82, okay, that means that you know regulation 82, and regulation 82 refers to the tariff, okay, so that refers to forms and tariffs, okay, and it says these documents that are prepared substantially in the forms provided substantially, listen, substantially. Okay, that's why I'm saying deviation is to your detriment. Okay, right? Those forms, there's a tariff that is published, a schedule of registrar fees that every year, normally it goes up by 20 or 50 Rand. Okay, and that is that part that I showed you. There's a stamp on that deed of transfer that says registered, the purchase price, and then what is the deeds registry's fee that is paid to the registry for purposes of registration, and that is the amount that's paid directly to the Department of Rural and Rural Development and Housing, etc., etc. Okay, so clear there. Once I've now referred to that, you know this off by heart. But our page starts off with a preparation clause on, if we prepare it, right top hand corner. And what does that preparation clause look like? Prepared by me. What are you? A conveyancer, because this is your draft deed. Marijke Prinsloo, if that's your name. LPC number, so LPCM 1234. Okay, and that's where that electronic thing is now coming in to make sure that Marijke is actually admitted as a conveyancer. Okay, then what else? So for purposes of my preparation clause, I have section 15, and I've mentioned section 15 a couple of times. Okay, here I've said prohibits a registrar to execute a deed of transfer unless it's prepared by a conveyancer. A deed, okay, must be executed, prepared by a registrar. Okay, So go and look at your specific wording for section 15. It's very important. Yes, for the drafting exam, you will have the act and the regulations, but it doesn't help you because you're going to be paging through a book and wasting your time. Then we have regulation 43, and I said to you 44 is also important. Every deed must be yes, yes, I see a hand, yes.
I just needed to understand, in terms of section 20,
yes,
it would seem that a lay person who is an owner can execute a deed of
yes,
transfer before the registrar, right?
yes.
But they can only execute that deed which was prepared by a conveyancer. They cannot prepare their own in terms of section 15.
Yes, exactly. Exactly. So let's say, for instance, let's think of a situation. It's actually very it's a very strange provision, because nobody, a lame person will not, as owner, will not know how to really do this and prepare this properly. However, let's say, for instance, this is a practitioner and he gets sick. Nothing prohibits that practitioner to say to the owners, you can go and sign your deed. You can go and sign it. You must just speak to the deeds registrar. I'm deadly sick at the moment. Maybe I'm in isolation and there's no one else that likes me or is willing to appear on my behalf, because I've made enemies and no friends. Then he can actually say, "Is okay, we've got a problem here. You need to go in and appear in front of the registrar." Okay, but that is like, I've never heard of anybody ever doing that. Okay, so it is a possibility, but in practice, never heard of it. Okay. But there's always a first time for everything in life. So the regulation 43, very important there. Remember, the change is, if you go through your legislation book, you're going to see that it clearly makes it known that now you have to have an LPC number in your PrEP clause. Okay, so guys, that's section 15 read together with the regulations 43. It tells you everything that relates to what you have to have a preparation clause in, and specifically if you look at 43 subsection 1 on the regulation side, you now know this off by heart. After today, you know this off by heart. And it basically relates to certificates, deeds of cession, bonds, all of them. They all have to have a preparation clause. And that means also that they all start at the top right-hand corner, half the page open, heading. If it's a certificate of registered title, then the heading is only that, certificate of registered title. Okay, if it's a certificate of consolidated title, it's exactly that, a certificate of registered consolidated title. Okay, if it is a mortgage bond, it will say mortgage bond. If it is a deed of cession, then it will say notarial deed of cession. That would be the heading. If it's a deed of transfer, it would say deed of transfer. And that's my heading. Half of the page down, heading. You do not put a title deed number there. Why not? Because the registrar is going to come with his little stamp on date of execution, provided I don't have rejection notes. Okay. So you now know this off by heart, and by knowing this, you know exactly which documents are executed by the registrar, which are executed by the conveyancer, which are attested to by the registrar, okay, and which are attested to by the conveyancer, right? So importantly, important there to obviously remember that you have to, there is a difference between all of these aspects for purposes of knowing when do I attest and when do I execute. Very, very important. Now I have a question from Alan regarding section 15 capital A. Alan, you've asked how are we impacted by that? Well, very simply, Section 15, when we refer to the preparation clause in Section 15A, is considered to be a must know automatically by implication. Because Section 15 capital A is asked frequently in the short paper as to what you as a conveyancer are taking responsibility for. So again, guys, we don't have the time to go through the Act section by section by section. I've already said to you, you are required to know everything. So when I speak about the DRA, when I touch on only the important aspects or the major aspects, then all the subsections below that is by implication already within your notice. What we are doing is we are introducing you to concepts and we are introducing you to forms to make you pass the exam. But we can't teach you like parrots. Okay. So Alan is very good there to point out. But if you look at the Section 15A heading, you will see that it says proof of certain facts in connection with deeds and documents, and then lies your responsibility. Once you sign that prep clause, you take responsibility for everything in that deed. So let's quickly talk about that Section 41B. Now, what happened? Yes, absolutely accuracy in everything. If I sign any document that's registered in the deeds office, and remember this for notarial practice as well, you take responsibility for everything in it. Every single thing. You take responsibility that that document that is registered is the same if I compare it against the gross, then I will know that my minute looks exactly like that. That's notarial speak. Don't worry about that. If you're doing the notarial course, you'll learn more about that. But everything, whether it is, if you are referring to a private treaty, you take responsibility that a private treaty, that sale agreement hasn't lapsed. When you are transferring in terms of a CASA of the sheriff, transferring because of an execution, you take responsibility for the fact that that sheriff is duly authorized and that everything went perfectly correct in terms of that warrant, that it was attached, and in terms of the sale in execution, the conditions of that, all of that, you take responsibility for all of that. And that also means that if you have made a typo, because remember the data capturers and the examiners are also people, so they may very well miss a zero here or there or a spelling error which you didn't pick up, and they sometimes don't pick up either. That's where we bring that Section 41B, and guess what, then you have to pay for it as the conveyancer. And then if the wrong attorney brings that up, or conveyancer, or that wrong firm brings that application, then they summa charge you 8,000 Rand. And if there's delays, then they want damages for their clients as well. That is your responsibility. So don't be in too big a hurry to become conveyancers and notaries, because from here on, there's nothing that will protect you and nothing that will allow you to say, but I didn't know. Okay, so by implication, every document you sign, you take responsibility for the facts in that, the allegations, for every single thing that's in that, the parties, every single thing. That's why, again, I'm just going to quickly mention this to you. When you start preparing that sale agreement for a company, the first thing you do is you check whether they are still in business. Whether they are still in business. Okay, because once they are not in business as such at sub-C and recorded as such, then you can't prepare a valid sale agreement or proceed to valid registration. So very important there. Okay, right. I see there's no questions, so let's go on. So this is our heading. So here we are dealing with our deed of transfer. I'm going to first show you these things, and then we'll go to, because it's going to be easier to put everything together when we go back to the next chapter, or onwards to the next chapter. Okay, so this is with regards to chapter 3. Those of you find how I explain a bit confusing, we went through chapter 3. Okay, now we show where does it fit in to the bigger schemes of things, and we look we specifically refer to the legislation and the regulations involved. Okay, so there's the regulation. As I said to you, for everything we do, there's a regulation or a chief registrar circular. And again, you can't argue about everything. Do what you have to do to get the registration through. So top half reserved. Why? For the insertion of endorsements. And those rubber stamps that I showed you, those are endorsements. When the stamp is affixed to that half page that's open that says there's a mortgage bond, it's endorsed to the effect that this land is encumbered by mortgage bond. And then we have to know all the law relating to mortgage bonds that says I can't transfer land unless I cancel the bond as a general rule. Or what can I do else? I can substitute the debtors. I can, in some circumstances, substitute the property, but that's part of bonds. So let's not put the cart in front of the horse. Yeah, I did get that right for once. Okay, so what am I dealing with here? Form E, so it's a deed of transfer, a basic one. That's my heading. And then here we go. So let me just move my, I'm working off various computer screens, etc. It makes it easier so that I can see your comments, and so that I can see what you can see on the screen as well. So when you prepare your draft deed, you would start off by Form E, using the format of Form E, be it hereby made known. That what? That normally you leave this part blank. Okay, you leave this part blank. Why? Because you do not know if Mareike is going to be appearing that morning in front of the registrar, or maybe one of Mareike's agency firms or conveyancers, or whether it's one of Mareike's partners that's going to appear. So normally we leave this blank. Okay, but for purposes of your preparation in the exam and preparing your forms, you will insert any name in there. Okay, the shortest possible thing. Okay, make it short, and remember that the LPCM number has to be everywhere now. Okay, now, so be it hereby made known, and if you look at Form E, you're going to see that's exactly what it looks, how it continues on. The thing you have to guard against is thinking that you don't need to study any of the forms, okay? Because you are going to really waste a lot of time. And what I want to show you is, compared to what I've shown you, my mouse is dying on me. Look at this. Do you think you can figure out that that's supposed to be right-hand top half page open? Now suddenly you see this for the first time in the exam. Now you're going to use and apply it. Look at Form E. That's the whole Form E. So I need to know where that goes. I need to know what happens in between. I need to know what that is. Where does it end? And I have to certainly know how the layout should look. If I take this, for instance, where does my preamble begin and start, or begin and end? Where does my causa begin and end? Where does my vesting clause start and end? Where does my property clause start and end? You are going to have this form, but oh my word, how are you going to waste time to try and decipher what are you supposed to do with this thing and where does it start? Because you know what? A lot of the time in the papers, they say to you, prepare, here's the facts, cite or prepare the following clauses of a deed of transfer, and they would say, for instance, the CASA or recital and the vesting clause up and to the extending clause of the property. And if you don't know what they look like and how they read, you're going to be sitting looking at this form and trying to figure out where does what start and end. Okay. And that is why I said right at the beginning, you're going to get 2 boxes of rototrim or scrap paper from your office, and you're going to get 50 big pens, black ones, and you're going to draft because you've got to be writing fit. Okay. Right. So if you look at this, I can even, oh my word, how you will waste your time. I can just imagine what this feels like. I literally, I have to say this, is I went into the exam and we had a book that was given to us once, and I got back and at the end of the exam, and I was told, I said to them, what are we supposed to do with this book? And they said, you were supposed to use it for preparing some of your answers. And I was like, oh, no, I thought you had to know it off by heart. So, yeah. So you at least get the forms. But funny thing happened when you were given the forms and the act, suddenly the pass rate dropped even worse. So where we were at 25%, it came down to 13% and lower. Yeah. So think about that. Okay. Right. Sorry. Back to our presentation. I must just click on it. And there we go. Okay. So heading, appearer, we insert somebody. Now, here's where we have to remember, if I am writing in Johannesburg or Gauteng, then I prepare my documents with reference to be it hereby made known, whoever prepares appeared before me, who? The Registrar of Deeds at Pretoria, Johannesburg, Cape Town, any of those, okay? Yeah, so you insert that, and then it goes on in the form, he the said appearer being duly authorized thereto by a power of attorney granted to him by, and then that is my transferor. Right. So what is in my preamble? Firstly, the name of who appears. Secondly, the transferor's details. Okay, right? And then below, whoever is appointed here, or whoever is transferring, I have to say, right, so by power of attorney that was granted to this appearer, and just remember that if it's a her, and you know she's going to appear, you'll put in granted to her by, and then cite the property, the party as per the citation requirements, okay, and then following that, date, because it's by power of attorney granted to the appearer by the transferor, the owner, dated the 12th of April. Yeah, I did it again. I combine English and Afrikaans, and signed at Pietermaritzburg, or it could be signed at Windhoek. No, don't go Windhoek. No, forget that. Worcester, signed at Worcester. Okay, right. I just want to quickly look at the questions here. There's questions. Do you mind giving us the complete Form E so we'll should know how to complete it? Guys, Ndanganyeni, I don't understand your question. Do you have the legislation book? You can.
I do.
Okay, so you have the legislation book. The form is there. Then on e-leader, I give you examples of the title deeds. And today, when I showed you, just want to go back there and just see. Okay, no, not that one. Go away. There. I've just showed you a Form E. This is Form E.
Okay.
Yeah, that's a Form E. There's Form E for you. This is just executed in Cape Town. The appearer appeared in front of the registrar at Cape Town.
But it seems like a lot here, and in where it's incomplete, it seems short.
What do you mean? Explain to me.
Like, what I mean is that on the book, it's kind of short, like the details that are required, like completing like the dots that are the space.
Exactly. That's
missing words.
Yes, but that's my whole point. Thank you for mentioning that, because that's my whole point is you have to use my examples that I give you, okay, to go and prepare them. And I'm going to give you homework. I'm going to give you homework. I'm going to post you a request to prepare me a document from scratch, a power of attorney and a draft deed. I'll give you everything you need. Okay. And then you go and you prepare it. That's why I'm saying is when you look at the form, it's squished into one, but you have to know how to lay it out.
Okay.
And that's why we go through all of the legislation at the side. That's why I took the time to prepare a PowerPoint to say to you everything you have to know when you do a citation, when you do anything. Okay.
Okay.
Because if you don't follow the wording of that Form E, okay, and you lay it out properly, then you're going to be rejected in any way. And remember what I reminded you of, those examiners, they don't go and mark things. They look at it and they know, is it going to be capable of registration? So let's say, for instance, you might have let's say a prep note, okay? Some provinces call it a counter query. But still, the examiner believes this is capable of registration as long as you deal with the prep note or the counter query. Then they would give you maybe 60% of the mark if it was out of 45. But they're not going to sit there and give you 3 marks for the citation of the party and 3 marks if you prepare the full form. If you prepare the full form, they're not going to give you 3 marks for citation, 3 marks for causa, 3 marks for this. They don't do that. They look, would it only get a note by an examiner, or would it be full out rejected? If it's full out rejected, then you get naught for that question. That's why you don't get your papers back. You don't get your papers back. You can't ask for your conveyancing exam papers because there's no marks to lead you. There's no marks to lead you. Okay, it's either capable of registration or it's rejected. Okay, now one of the things I just want to show to you here, there's been a slight change. Look, this is 2017. There's been a slight change. There's been a very slight change to the layout of Form E. That part here, go back. No, let me show you the phone. Do you see here it refers to power of attorney, which said power of attorney was signed at Cape Town on the 17th of November, granted to him by, and then it's the transfer all. Now there's just been a simple slight change to the form. If you follow it, wait. See there at the bottom, it says, so now you have power of attorney granted to him by transfer all, and then the date and signed at Pietermaritzburg. You see, it's a slight change, but this is important. And that's why you have to use the legislation book that you get now, not an old act, okay? Because there's been an update of the forms, etc. Okay.
Okay, Marianne, do you mind sending us the document like this? Because the one that I'm having in my hand, I printed it out, and then the section 20 and regulation 82 and regulation 20, and then the preamble information, it's hidden because on top of it there is regulation 24. 1A. Yes.
There's two versions of the PowerPoint. The one is as you click on it, it opens up. Okay.
Yes.
Right. So that's how it's laid out for the lecture. So I can send it to you in the other format, but I can't guarantee it prints perfectly. The idea is that as you go through the things and you prepare your documents, as they open up, you can apply it. But I'll give you another lead that assists you with that. Okay.
Thank you.
Guys, I don't want to be one of those people that promises the world and then I don't deliver, which I really aspire not to do. Will somebody just remind me? Okay, not everybody, because then I'm going to go hysterical. Okay, just remind me gently, a nudge. Remind me, Marijke, CRC sees with citations. Marijke, please remember to upload this or that. Nicely. I also have a practice. Yes, so nicely. I work after hours. Okay. So, nicely ask me. Okay. So, and I'll post whatever I can on WhatsApp and email it to the people without WhatsApp. Okay. So, you just see, yeah, legislation bundle is your point of departure, but you need to know how to apply it. Okay. So now, what's next? Now, for everything we do, again, we end up having to refer back to the Act because we are told to the T what to do in conveyancing, to the T. Okay. So the first regulation you've got there, and I just want to make sure it is the exact next one, Regulation 24.1. Now, again, I'm giving you all of this. When we normally do a deed of transfer, it's assumed you know all of these things. So, firstly, identity number and full names. Now, what happened? What happens if the person hasn't been issued with an identity number? Okay, then I have to refer to his or her date of birth. I keep on referring to his and her and all of those things because that is the legislation at the moment. I don't know what's going to happen in future with the non-binary generation or the gender fluid situations. But until we have legislation regulating that, we basically refer to a person being born and we cite them by way of the identity number, which will tell us at this point in time, is this a male or a female person? But we live in a world where things change. So very important there. I always find it interesting that they thought it was important to say to us, you can't use an alias. I always thought that only crooks uses aliases. Yeah, I thought thieves do that. So it was interesting that the legislator thought that's a good idea to say that. There's a hand. Is it Sarah?
Yes. Marijke, but the birth certificates for now, they're coming with the number of an ID.
Yes, I know.
So you can actually know if it's a minor or an adult.
Yes, that is the whole thing. But now again, yes, the birth certificates come with an ID number. So from that ID number, you would know whether it's a male or a female. If you had to deal with, say, for instance, preparing an application where you have to say he or she. Okay, so that's the one thing. The other thing is we cite minors differently at certain ages, and that's where the citations comes in. Okay, and that is why after tomorrow you'll have a voice note on the citations in the vesting clauses. Okay, in a couple of days. But firstly, you'll have a voice note explaining citations in the power of attorney and then in the preamble as the transferal. Keep them apart. Some people say some people are known by alias like Ace or Tokyo. Okay. I didn't think that's an alias. I thought that was just like a nickname. I always thought aliases means something different, nicknames. Okay. So to a person's name, so you have to basically refer to the fact that the person has an identity number. They get it. But what if it's a foreigner? If it's a foreigner, he doesn't have an ID number. If it's a non-resident, he might not have an identity document. He might only have a passport. So under those circumstances, if they don't have an identity number, okay, then we have we refer to the date of birth, okay, for say for instance a foreigner or not a non-resident, a foreigner basically. So that's very important. So you have to know 24.1 and 24.2, the regulations off by heart and understand them, okay? Then 24.1 basically says full name and registration number of, in case of other persons. Which other persons? Trusts, companies. Okay, so companies and trusts. Okay, so if we have those, and you'll have all the examples of the different situations, and that is why Alan mentioned the CRC on companies, okay? Because if we are dealing, and in my example, we used a company, so immediately you have to run through the company law and that CRC in the back of your head. And I would love to have some feedback at the end of the session, because in the past I have heard that I'm not structured in the lectures, and to me it's not possible to just follow a structure, because you have to know all the law at the same time. So you have to apply it like that. But you can give me feedback on whether or not this is structured enough for you or not, and I'll try and adapt. So in the case of a legal entity, okay, then we have the full name and the registration number. Okay, so again, I'm just going to emphasize no ID nor, no identity number, no reg nor, no registration number. Okay. When we deal with trusts, I'm going to show you how we deal with trust, because they have IT numbers or MT, mortis causa trusts, or inter vivos trusts, IT or MT. So, and we refer to them as per the deed of trust. Interesting point there. Remember that, put it at the back of your head. We'll come back to that. So, then we go on to section 17.2 of the DRA, because now we're defining, or we're telling people how do we cite parties, full name and marital status of the person. So in my example here, the transferor is married out of community of property. Okay, so if I'm married out of community of property, either spouse can bind their own name. Okay, and that is why this person is just his name, identity number, married out of community of property. No reference to accrual or not. No reference to accrual or not. Okay. It doesn't matter. If they're out of community of property and not in community of property, you cite the either or. So in other words, either both parties, or if they exclude it from the joint estate as the asset, then we deal with it, and you'll see why. So the other thing here, the next thing is estate in or out of community of property, or governed by customary law. Okay, and we're going to come back to that, because that's a huge part of law. Okay, and remember, I had a situation where I was told recently by a party that they were married customary, and I just thought, because this person was like working for the bank, and I thought, but surely you know, never assume, surely you know. And I said to him, sir, you are not African, you are not married customary law. So I thought he would know that customary marriages are reserved for African people. Okay, so yeah. Part of a house is the tradition. So, and none of us are part of the house, basically. So, important there, those customary laws, and we'll go into depth with that because you have to know everything relating to that and how it's applied. Then, obviously, when it's married in community of property, state the full name of the spouse, and that's where we get into that. John Doe, identity number 720-525 6113081, and Jane Soap, identity number 720-525-0112081, married in community of property to each other. No numbering of the spouses. But what if the spouses were married out of a community and they were both transferring the property? Then it would be number 1, Joe Soap, identity number, married out of community of property, and 2, Jane Soap, identity number, married out of community of property. Okay, so two numbers, never numbers with a community of property, as long as because there's a joint estate. Okay, and that estate is only divided on divorce or death. Okay, or court order. So section 20 and section 21. Okay, remember those, section 20 and 21 of the MPA. Okay, so married as in community property. If the person is married in accordance with the laws of another country, if he transfers, remember we are now on the preamble, so we're only dealing with the citing of the transfer law. Carla, I'm going to answer you now. We're only dealing with the transfer law. So if the person is married in accordance with the laws of another country and his deed is in the name of only him because he acquired it as, let's say, Jaap van Stiertoren. He's from the Netherlands and he's married in accordance with the laws of the Netherlands. So it would be Jaap van Stiertoren, born 15th of December 1947. Okay, married. Married in his title deed, it would say married. Which marriage is governed by the laws of the Netherlands. Okay, but now if he wants to transfer, then he has to have the assistance of his spouse, irrespective of whether or not her name is on the title deed. Okay, we're going to look at how that is dealt with. Okay, then oops, sorry. I'm going, Carla, I see you. Coming back to you. I just want to finish this one. 181A1, identity number of a natural person by means of full name and identity number as reflected in the identity document. Okay, but now identity documents are falling away. We're getting smart IDs. So now we have to consider what is the best proof of identity. It's the birth certificate. Always the birth certificate takes precedence over anything else. Okay, so please look at those regulations, and then the other, the last thing is regulation 17.2b, any other person, the name and registration number of, if any. Okay, so we're going to look at all those citations and how these different regulations applies, because one of your your supporting documents, it's not your lodging documents, it's your supporting documents that you have to obtain from the parties is an affidavit, a personal affidavit that says what is his ID, what is his full names, his identity number, or his date of birth, and then you have to allege that he's in possession of an identification in terms of regulation 18. We'll look at that as well later on. Okay, so Carla is asking what happens in the event where there are where there is more than one wife. Would all parties be cited? That is a part of that CRC of 2013 that I said to you, that sets out the Customary Marriages Act. And I don't want to spoil this presentation here with going into depth with that, because we're getting to that. Okay, so these are just the law that's required to be known in preparation of Carla, I'm sorry, but you just hang in there. We're getting to all the detail. So this is just for your formality and what you take responsibility of. When you sign that prep clause and you execute that deed, that's what this is about. So this tells you the law applying to your Form E. So then my next point is my recital, and my recital is the reason for the transaction, whether it is a private treaty, which is a sale, or whether it is a deed of donation. And we'll come to all the law relating to deed of donations when we deal with more causa. Okay, so for purposes of a sale, okay, we basically just refer to that appearer. Remember that appearer that's going to be there to execute. That person appears and he declares that his principal had truly and lawfully sold, or truly and legally sold on a specific date, and that the appearer in his capacity aforesaid did by these precedents cede and transfer to and on behalf. That is where your causa lies. Date of sale, private treaty, truly and lawfully. That's it. Okay. And then that wording comes from Form E. Okay. But if you don't know how to use Form E, you're going to sit in the exam and you're going to waste your own time. I just want to see here, Faith Hunty says, will the examiner penalize me if I use an English name and surname like mine to cite customary law spouses? Sorry if it's a silly question. Not at all. Who are we to judge? I mean, really, who are we to judge? I mean, I know of a lot of people that has historically Afrikaans names, and that doesn't mean they're white. Okay, so no, it doesn't matter. Okay, so that is our reason for our transfer. I see Sarah's hand is still up. Do you still have a question, Sarah?
My apologies. Yes, I had a question on our manual, training manual, page 63. I just wanted to know the citing of the parties. I'm actually a bit confused. I think it's paragraph of the 6th paragraph where they're citing John Alfred Ndlovu, married in community of property to each other, to Amanda Ndlovu, and John Alfred Ndlovu, again married in customary law because he didn't apply to court to declare the other marriage. So my point of question is Amanda joined in every activity that Alfred is doing, seeing that he's married twice?
That is a customary marriage. So that's a polygamous. That's a polygamous customary marriage.
Yes, so, but it was firstly a monogamous one before.
Yeah. Now you have to look. Did they record this? There's specific law that's related in that CRC and in the customary, understanding customary law specifically, and we're going to look at that specifically.
Oh, okay. Is it part and parcel of what we're going to be dealing with about Carla's question? Is it part and parcel of it?
Yes.
Okay.
Yeah.
Okay.
Yeah, that's coming up because the reason why I'm only introducing certain aspects is to allow you to practice standard easy things, and then I go into the law. Okay. Because if you don't understand the law in any event, then you're not going to. Why are you using the right citation if you can't sit with the client in front of you, ask the right questions, and get the right affidavit to determine whether or not they are married in community, out of community, or in accordance with customary marriages?
Okay. No. Okay. Thank you.
That's the point. We're getting to that. I just want to go through a very plain and simple Form E to get you to start drafting. Okay, so just bear with me. I know it might be frustrating. There's 20 lectures. Get the basics under your knees, okay, to start practicing drafting, and then incorporate the extensive, the vastness of the work. Remember I said to you, I'm going to actually do with you that very long section for that very long question, and once you see how we analyze it in the exam, you're going to see why I do things the way that I do in the lectures. So bear with me, okay, please. Does anybody want to break now, or are we still A4 away? Can we still continue? I'm going to take my cue from the first 5 people who answers me. Are we continuing?
Yes, we are continuing.
Okay, sorry. You guys are too fast. Yeah, Alan said go on. She's saying go on. At least 8. The thing is, guys, please continue. Okay, I'm continuing. Thank you. I'm going to continue. The thing is, guys, is I'm sorry, but I can never stop early. That would be, I don't know. I can't stop early. Never ask me to stop early, please, unless I tell you I'm going to fall over now and die. So I have to stop early. But then I'll probably come back later and send you emails. So, okay. So we've got now our recital. That's the reason for our transfer. Okay. Now, this is where we get to our vesting clause. Okay. Now, because the transfer rule here is a CC. Okay. The transfer rule here is a CC. So in this situation, then we know that, okay, in terms of the Companies Act, this is also now deemed as a company. So how do we refer to the succession clause? This is where we still use successors in title, because his title is a member in that CC, and in all likelihood he's converted subsequently, which we're going to show you in an application, or how we deal with those conversions in future as well, part of company law, the conversions. Here, one of the things that's important that, and I specifically did this in this manner, is because I give you other examples. I've just said to you no regno, so it's registration number. The only abbreviation allowed here is that CC. CC can be abbreviated to from close corporation. But if your deed is saying all trading 3322 close corporation, the holding deed, then you have to, then in the preamble, you still have to use all trading 3322 close corporation. You can't then decide I'm going to abbreviate it, because then you'll be rejected. Okay, so registration number, this is a CK, a CC. So how do we know that? The number 23 at the back says it's a closed corporation. The other thing is, normally it has the CK number here. Okay, so it depends on what is on your verification documents. So your certificate of incorporation, the old forms for your CCs, the CK1, etc. Okay, those are old forms. Now we don't deal with the CK1, etc. Now we deal with the COR 14s. Okay, so important there. Pty Limited now changed as well, so to full names. Is Pty Limited now changed as well to full names? No, Pty Ltd is still acceptable. Okay, because CCs and Pty Limited, those are acceptable. Remember, I said to you never again ID no and never reg no. Okay, I said to you the only abbreviations that is allowed are the ones that I'm going to tell you about, and those are CC and Pty Limited. Okay, and you take your cue from your holding deed. Okay, but in your vesting clause, you're not going to have a holding deed. Okay, because this is now your your new buyer, your new owner that's being vested. So you have to make sure you have the right identifying documents to identify the details and what the name is, because sometimes there's numbers in the name, sometimes there's no numbers in the names, etc. Sometimes a full name close corporation appears as part of the name. Okay, and then my succession clause here, the successor in title or assigns, in full and free property. Why? Again, because it's not freehold. A couple of weeks ago, the bill for upgrading of land tenure has been published. So we keep our eyes on that bill, because if it's passed before your exam, you have to apply it. I will upload the bill, but it's actually, I'm not going to upload the bill, because until it's law, don't confuse yourself. So just bench that point. You only write based on the law that's applicable at the time of your exam. Okay. So here we basically say our vesting clauses that transferee, and that's in. This is where I said to you that succession clause is B, succession clause. So for my natural person, we are going to say John Doe, identity number, unmarried. It's success. That's wrong. His or her heirs, executors, administrators, or assigns. Now again, if it's a male, you will say his heirs, executors, administrators, or assigns. If it's a female, because you look at the ID number, you'll say her heirs, executors, administrators, or assigns. Natural person. If it is a local authority or a CC, we're going to say it's successors in title or assigns. Why successors in title for a local authority? Because maybe the name of the local authority is amended, or other land is incorporated under the local authority, and therefore the name is changed. Any of these reasons would literally refer to, or any of these situations carries the succession clause as successors in title or assigns. Why? Because that legal authority, local authority that is vested with land, the governing persons in terms of the local authority may change from time to time. So it's successors in title. And then if it's a trust, it's the successors in office and assigns. Those are my succession clauses. Faith Hunter says page 68, paragraph 4.1 says not to abbreviate PTY. Then further it says not to use the brackets. Those abbreviations, if it's in your holding deed, you still use them. Okay, that's the first thing. The second thing is those are the acceptable abbreviations. I will upload the relevant CRC with regards to that. You also have to remember, Faith, where are you based? Just type quickly. Are you based Gauteng, Johannesburg, which area? In KZN, Pietermaritzburg Deeds Office, Johannesburg, you might have a registrar circular, not a chief registrar circular, but a registrar circular that could say to you that you're not allowed to have PTY limited. Okay, so we'll look at that at a later stage again. In KZN, we follow the holding deed and the documentation provided to us, so that still is acceptable. Okay, if anything changed overnight, I will phone a friend and find out. Okay, I've already said, Carla, she says, how do we refer to a transgender person in accordance with the ID number? There's nothing except, there's no legislation that deals with transgender identification yet, so you will use the identity number as at this point in time. Now, listen to me very carefully. There is an application that's part of your endorsement and the endorsements and sundry applications, which is Section 3 of the Deeds Registry Act, that allows for having a title deed endorsed to state that a certain person has changed its sex and is now known, I call them the Caitlyn Jenner section. I call that section the Caitlyn Jenner section because if you remember, it was Kris Jenner, the guy, and then he changed to Caitlyn, okay, from the Kardashians. So that section allows a title deed to be endorsed. You bring that application, you provide the proof that the name has been changed, the sex has been changed, the person as such basically changed in itself, and then you endorse the title deed. So those things we deal with on endorsements if it happens after transfer, but at the moment we don't have legislation that says, right, a transgender person is referred to as, say, for instance, a completely different set of digits between following on the date of birth. So we would just refer to his and her at this point in time. We don't have an it or a them or a they yet. Okay. Right. Okay. So now we're continuing. Vesting here must be registered name for the husband and the wife if the property is held upon transfer forms and it forms part of the joint estate. So that's 17.1. So that would be Joe Soap identity number and Jane Soap identity number, married in community of property to each other. Then 17.3, when the marriage in community of property is dissolved by death, then we have a situation where the joint estate of the spouses basically passes transfer. So we will deal with this under section 21, which is right following on Form E. And when we do estates, always remember I have to first look at section 21 because it says I will always add the surviving spouse to the citation with the executor. So the executor gives transfer together with the surviving spouse and then follows all the exceptions. And we'll deal with that in estates. Okay. So just to push on here, now we are dealing with property. Is everybody still okay? So now, for instance, we have the property description. This whole description here is the perfect, thank you, everybody's still with me, perfect property description, okay, for Gauteng, 322 Dundee Noord, if that is what your township is named. And then if there's an extension 20, follow your deed. If it says EXT, then you use EXT, the abbreviation. 20, township. KZN, you will only have Dundee Noord, extension 20. That's it, no reference to township. Registration division JR, province of Gauteng, in extent 582 square meters. See, this is the property clause. That is the property clause. So let's look at which regulations are governing this. Regulation 28. Here again, I'm going to refer to my administrative district if it is Cape Town, okay, or Western Cape. If it is most other provinces, it will be a registration division. And I've explained to you why we have the registration, because I showed you that extract from the Free State Cadastre showing those two letters. Okay. Remember, I also said to you that I recall from my time as a conveyancer in Gauteng that a lot of them were JR. Okay, so JR, normally you can always use JR if you have to make up the information in the exam. Okay, so administrative district, if we have used that in the Cape, and obviously say the name of the township, and we would refer to the province. Then will I be marked wrong if I write JR instead of FU? You will not be marked wrong at all. FU is normally in KZN. So JR, if you're writing in Gauteng, use it if you have to make it up. Otherwise, use any letters you want to. Okay, so that was from Mondi. Then regulation 28.1, the registered number of land must be disclosed. So in other words, earth number. So earth 32322. Okay, see what I mean? Everything we do, we're told to do it. Okay, regulation 30, undivided share is being dealt with. The share must be expressed in one fraction in its lowest terms, where the denominator exceeds 2. Oh, sorry, I have a spelling error there. 2. Oh, you know what? How do you know Marika prepared something herself? Is when there's a spelling mistake, because Marika is actually a bit dyslexic. Okay, so where the denominator exceeds 2 figures, the fraction is then expressed as 6-figure decimal. Okay, so remember that. So I can only go up to let's say 1/99. Okay, the moment I go over 2 figures in the denominator, then I go into my my decimals. Okay, but when we deal with our subdivisions, etc., then I show you how that works in practice. Okay, regulation 29, extent must be expressed in words and figures. Okay, words and figures. And then regulation 27, the deed includes more than one property. Each property of land must be described in a separate paragraph, which must be numbered. One of the important things to remember is that I asked you in the pre-assessment what happens with 10 properties, and a few of you realized that I can put them all in one deed. I must just describe them each in a different paragraph that is numbered. Okay, so that's very important. 27.1. Okay, so next, okay, we get to our extending extending clause. Okay, give Marika a moment. Thank you. So we use form TT or form UU. We're going to do this in depth when we do certificates of registered title and when we do the plotting of conditions, which follows, I think, chapter 7, 8, or 9, somewhere there. Right. So we don't have to say much about it. But as I said to you before, this tells me the history of the property. It was first transferred, okay, by this deed of transfer. And that deed of transfer stems from a general plan issued by the Surveyor General, that SG number, that number. So if I go and look at that general plan, I'm going to find earth 3322 on that general plan, and it's going to tell me how big that earth is. Okay, so in this case, as I said to you, first transfer by deed of transfer of 2001 with general plan SG number relating thereto. Remember I said to you, I can't attach a general plan to a title deed, so I will always say relating to, not annexed thereto, but relating to it, because it's an A1 sized huge plan, whilst if it's a diagram, then I'm going to say with diagram SG number annexed thereto, annexed to that deed, because it was first transferred in terms of that deed. Okay, that had a general plan, a diagram attached, and held by deed of transfer now the 2006 deed. Okay, don't stress about this too much. We're going to do this in depth. And then if the portion of land is already in existence, we use form UU, because this already exists. It was created on a general plan. But if it's not already in existence, then we use form TT. That's that we refer to the diagram, and that's where we always know it's going to say, as will appear from a next diagram and held by the mother deed. Okay, the mother deed as the holding deed. Okay, we're going to play around with those concepts. Can you understand now why I'm saying to you, let's just get this under our knees. Then we go into the chapters that's going to follow that makes it complicated or more intricate. If we can get the bare necessities right, we're going to be A for a way. Regulation 43.2, if we change anything to a deed in a condition, etc., then we have to have it initialed by the conveyancer. And then remember I said to you, you have to draw a line straight down if there's an open space. And I said to you, we even told that we must do that in terms of Regulation 22. Now, I was a very green conveyancer, and I was sitting for some reason in the Durban deeds office, and I just had I ended up with all of these really experienced conveyancers, and they always used to bully me to an extent, because they would always say, we're waiting for the red R for a rejection, and then we're all going to laugh at you. And the one day I got a prep note and it says Regulation 22. And I was so embarrassed. It was just a prep note, because all you need to do is just go and take your ruler and then and there, take the note and quickly draw it through. It's not a rejection note. And I had such a fright that I actually said to them, what the hell is a 22? And they said, no way. Surely you know what a 22 is. And that was, I didn't line through the space. Okay, so Regulation 22 says number your pages and line through all open spaces. Okay. This relating to vesting clauses basically is a repeat from the previous slides, and then our conditions. Okay, now these conditions you take over as they are from your holding deed. You take the conditions from your holding deed. There is a hierarchy for these. Okay, we deal with our existing conditions at the different levels that they are imposed, and then last is our newly imposed conditions. Okay, but when we plot conditions, we'll show you that as well. And then every page must be initialed by the conveyancer that executes the deed. Okay, we normally initial all the pages when we prep in any event. Okay, when you sign the prep clause, we always initial all the pages as well. So there's all of our conditions. This is the general clause I've spoken about before. Certain provinces don't have that. Refer to what is acceptable in your province and what is practiced there. Then your divesting clause, who now is no longer owner and who becomes owner. So here we normally look at this. We would say you have a choice. You can either say Johannes van Tonder, but you have to add, okay, you have to add married as aforesaid. If Johannes van Tonder is not married, okay, then you would say unmarried and not married as aforesaid, because then you'll be rejected. You can also say transferor. You can state transferor. You don't have to put the party in there, okay? So your choice, proper drafting, put the party, married as aforesaid or unmarried. Then who are you? All of this, you follow the wording of Form E. Then who is vested? The new transferee, successors, in title or assigns. And then we go to the consideration clause. Okay, see here I said the full marital status does not have to be disclosed. Okay, and you can even say you divest, you could even refer to the transferor. Okay, so no reference to saying, for instance, married out of community of property. You just say married as aforesaid or unmarried, and then your consideration clause. Interesting here. Remember, good practice, put numbers first, then letters. So follow that in your consideration clause, and then your execution. Okay, who executes? It's executed here before the appearer, before the registrar, and the registrar signs the date of execution, but he attests only because you as the conveyancer, you execute. Okay, right, and he signs that the last part of here he signs, and you would sign here. Okay, so that's basically, and he stamps in normally or writes in the date there. So this is the pulling apart. This is the pulling apart of the different aspects of a Form E. Okay. I'm going to quickly check for questions. There's a hand up by Advocate Ngobeni. He puts up his hand and I start sweating. Yes. Hello. Question? Hand up.
There was a question on exchange transfers earlier on by one of the candidates. So I think it pertains to this part where now what price or consideration would you reflect under this purchase price when it is an exchange where there was no additional payment made?
If it's no equalization payment, okay, if there's no equalization payment, you would refer to in your power of attorney and in reference to your consideration as the declared value, and you cite the declared value of the equal valued properties that are being displayed exchanged. Okay, this is in cases where I have equal valued properties. However, if I have to put in add a payment to equalize the value, then we would refer to the highest of the values. Okay.
Okay, so we would refer, in other words, so how are we then going to phrase this? Because here you're saying finally acknowledging the purchase price to be the sum of da da da. So in the case of exchange, what are you going to say? Finally acknowledging there?
Firstly, your whole causa is different. Okay, your whole causa is different, and we deal with the causa for exchanges. And secondly, when we then here refer to the purchase price, we refer to the properties separately as their values and their equalization payments if necessary. So we have an example that's coming up just in the next lecture under the causa of the exchange transfers. So just wait until our next one. Just
I shall
this
be
one,
patient.
please. Okay. Because there's a lot of people that isn't even thinking yet of exchange transfers, and that's still coming up. And our donations are coming up, and our sheriff transfers are coming up, and transfers that are done from in situations where debt rescue occurs and things like that. All of those are coming up in our causas and all of that. And also rectification transfer, because you could have asked me that question as well with a rectification transfer, and we deal with that in a very specific way as well. Okay. So I don't want to preempt that at the moment. We just want to look at our basics, parties, properties, the sequence of our different aspects of the deed of transfer, very important, okay? And then what do we have to know when we draft our document? So for this now, we are done with the presentation, and now we are going to this. I will send this to you, but I'll also send you a recent one with the new form where it has the reference to the date of signed below the preamble, the transfer rule. So, but I think this one is on eLeader. There's a couple of them on eLeader. Then, as I said to you, I don't believe that you can do or prepare a deed at this point unless you can draft a power of attorney. So in the next 15 minutes, I'm just going to quickly do a power of attorney, okay, a basic power of attorney, in order, because I'm going to ask you to prepare, given a set of facts, I'm going to ask you to prepare the power of attorney and the draft deed. Okay, that's going to be your assignment. Okay. So just quickly to just step back from here to the power of attorney. Are there any other questions but that relates to our causas? And I think the causas comes up, I think, in chapter 5 or something like that. I'm not quite sure. I don't stick to it just like that. So let's quickly look at the power of attorney. Unless there's any questions, let's quickly look at this. Now, remember I said to you, go back to section 15, compare section 15, no section 15A, DRA, then go on to the regulations, regulation 43 and 44, okay? And this is where you're going to find a reference to the fact that if I'm an attorney, I may prepare the prep clause. So I may sign a power of attorney. But if I lodge it at the deeds office, then I have to have it countersigned by the conveyancer. Okay, so go and look at specifically what the regulations say about this. So what's different here from the deed? Well, firstly, there's no half page open because there's not going to be any there will not be any endorsements on this power of attorney. There will never be on a power of attorney to pass, transfer, and endorsement. Okay, why? Because it's not a title deed, and it's definitely not a certificate of registered title. Okay, so what do we do in a deed of transfer? You know, it's so simple. You're going to basically deal with a transfer rule that appoints somebody to appear in the deeds office to transfer the property to a certain person, and I've got to describe the property. And I've got to just refer to what was my causa. So very simple. You should not ever lose marks on a power of attorney. And yes, you are asked frequently to prepare all the documents that is required to be prepared for purpose of lodgement and registration in the deeds office. And then you have to know, if they say prepare all the documents that it's a transfer, I have to have a power of attorney that is prepared. And then after that I prepare my my draft deed. And if it's for instance, a partition transfer, I need to know how do I deal with and what's the differences between the process. Okay, so let's quickly look at a plain and simple one. Okay, first thing is I'm passing transfer, so I the undersigned who, I use my own details, married out of community of property, a plain and simple one. Now, why is it so important to understand powers of attorney when you want to prepare deeds? Here, if this is an estate, you would refer to the executor being duly appointed by the Master of the High Court, okay, and which seat the Master is referred to. So in other words, if the Master of the High Court, Durban, I would have to say the Master of the High Court as executor, appointed in terms of letter of executorship, dated on the date, issued by the Master of the High Court, Durban. So there should be all these little tick points in my head when I prepare my power of attorney, because you're not going to get an easy one like this. You're going to have to refer to authorizations. That's what we want to see, is if you understand that if you're acting in representative capacity, do you know what to do and what you need to have in your citation, in your power of attorney. So if it's an estate transfer, then we refer to the authority, which is what? The letter of executorship. If I am appointed in terms of an order to act as curator bonis, There's the Afrikaans coming in again, curator bonis. I would have to refer to appointment as curator bonis, and also refer to representative capacity. We give you I give you on the voice notes examples of every scenario in this regard. The other thing is usufructs. They like to ask you usufructs for purposes of estate transfers, because we want to see, do you know you have to deal with the bare dominium owner and the usufruct owner, which is a limited right. So first thing is who always am I power of attorney? Cite my representative capacity and the owner who you represent. Okay. So refer to in representative capacity, my authority for representation. Then do what? Nominate, constitute, and appoint. That's the only thing you have to have there. And there's no form for this. There's no prescribed form. So what you don't have to yes, you put the Mondi, you put the master's reference always, because it's like I said, letter of executorship number, and then issued by the Master of the High Court Durban at Durban, Master of the High Court Durban at Durban on 29th January 2002, for instance. Okay. So yes, master's reference always for representative capacity. So owner, representation, transfer for all, no half page open, prep clause still, do hereby, and that's it. Nominate, constitute, and appoint. NCA. Nominate, constitute, and appoint. If you've never prepared a power of attorney, that's all you need. Nominate, constitute, and appoint. And you have to have at least one person has to appear in your power of attorney. I remember when I just arrived in KZN, deeds were being rejected, and then you link with them, you may be the bond attorney, and then the transferring attorney's documents are rejected because they didn't insert a power of attorney. And I used to think, how is that possible? Because the basis of a power of attorney is to appoint somebody. And if you don't put somebody in, you don't have a proper power of attorney. Your document is defective, but somebody prepped it, and they were happy to do that without any person being identified. As I said before, sometimes you have to add a person because there might be an additional conveyancer that joins your agency firm in between you preparing your documents, and that you allow that is allowed for. You can add the one person there, subject to initialing. Okay, so at least one person initialing if you add. Okay. And then after nominate, constitute, and appoint what? Obviously with the power of substitution. And why? Because sometimes you need to substitute the person. And mostly you do not want to be caught with an invalid power of attorney if you don't have that right. So to be my true and lawful agent, to do what? To appear. Where? At the deeds office, at the office of the Registrar of Deeds at Pietermaritzburg, or even at the deeds registry at Pietermaritzburg, which is also fine. Okay, because there's no prescribed form here, as long as you identify the registrar in which province or in which seat you will be appearing in front of. Okay. And there I'm going to act as agent, obviously, attorney and agent. Okay, and I cite my registrar. And what do I have to do? The person that I appoint must just go and declare, I as a transferor has sold, or I did on the 14th of July 2018 sell to. Look how simple it is. No formats. It's up to you how you want to draft your power of attorney, as long as you have the basics. I, owner, representation, do hereby nominate, constitute, and appoint who? With power of substitution. To do what? To be my attorney or lawful representative and agent. Okay. And then we continue on to do what? To appear in front of the appropriate registry, or in the registry, in front of the registrar with its seat, and do what? declare I've sold, or I've donated if I donated. So it depends on what your situation is. So there again, now my causas. This is why I say, if you don't have a sale here, you can't have in your deed a causa that says it's a sale. If it's a rectification transfer, I have to have a rectification causa. Yeah, I can't say that I declare that I, as the transferor, did on the 14th of July 2018 sell to somebody. If I have a donation, an exchange transfer, a rectification transfer, any of those. Okay, that's why causas are so important. And again, I'm going to emphasize that you can't prepare a proper deed if you don't know how to prepare the power of attorney. The two go hand in hand. Okay, so sell to Andre Griffiths, identity number, full out, writing out identity number, married out of community property. That is the transferee. Okay, here you can insert to say hereinafter referred to as a transferee, but we don't do that. Why? Because we're clever, we're attorneys. I just said here, this is the transferee to draw your attention to the fact that where would I find this in the deed? In the vesting clause. And then I say my consideration clause for the sum of 1 million rand. So I did sell on a specific date to this person for what? 4 million rand, and then I cite my property. So here we're dealing with portion 1 of 1, 2, 3, 4. Margate, right? No township. If you have a Margate in Gauteng, you're going to say Margate Township. Registration Division FU, Province of KwaZulu-Natal, in extent 415 square meters. And then what's my holding deed? Held by deed of transfer. See how fast you can prepare this. You don't have to sit and think. But if you don't know what to do or where to start with the basics, then you're going to sit and waste time. And you're going to come out and say, I couldn't finish. Okay. So again, I'm going to say to you, do not go the route of using the software applications, because just to quickly show you again, this example of our power of our deed. Look at this long-winded story here. If you're going to try and learn that off by heart, just waste your own time. The only thing that you have to basically say in your power of attorney, a basic one, is just, I'm going to cede transfer of the property. Okay, I'm going to renounce all title and interest in and to the property. Okay, I'm going to obviously transfer the property free. Okay, free of all encumbrances. So, firstly, I'm ceding and transferring the right into it. I'm renouncing any rights and interests. I'm transferring it free from encumbrance. Okay, and then I have to say, I allow for my agent to ratify and confirm. So this person is appearing, and he will have all the authority I have. So I have to say, I ratify and confirm whatsoever my agent under this power of attorney lawfully do or cause to be have done in terms hereof. That's my divesting clause. Okay. Now we get to conditions. The only time we are putting in additional conditions is if we are creating them under the few situations where we can create them. If we are bringing forward a condition from a will, we would insert it there. So as a general rule, we don't create conditions. But if we deal with, on the exceptions with an estate, we would carry certain conditions forward that are in the deed, in the will. And then if we are, in terms of a will or anything else, with a subdivision, etc., creating certain servitudes. So for instance, if I'm subdividing and there is and I'm transferring of land and I'm retaining land under the same title, but I am creating a right of way, for instance, that's a prioritial servitude, then I would create the condition here. There's exceptions to when I can create them in the power of attorney, which is why I said to you, don't stress too much about servitudes, we get to them in depth. Okay, everything that you learn here is less to learn when you do notarial work, if you learn it properly. So we can create servitude here. Okay, certain circumstances it's allowed for. We can create personal servitudes or predial servitudes under certain circumstances, and then we can bring conditions forward from the will. So then we would create them. A simple one would be is if the property is vested to an heir and the will says it excludes the community of property, then we would insert the community of property is excluded. We would take that condition from the will and put it in there. Okay. And then the law relating to powers of attorney signed in front of 2 witnesses. Okay, signed in front of 2 witnesses, 2 competent witnesses. Your pre-assessment, we dealt with that in depth. Those witnesses are not required to be 16 years of age. We're not talking about the creation of a will, etc. We are talking about competent witnesses, which is declared to be the age of 14, provided they understand the consequence of their actions. Sarah is asking if there are no new conditions. If there are no new conditions, then all you end off with is I hereby ratify and confirm whatsoever my agent is to do or may have done, period. That's where you stop. Okay, in terms of this power of attorney, that's where you stop. Nothing, you don't leave anything blank. You just stop there because you don't have new conditions that you create. Sign it and date it at a specific place and on a specific date. Have my witnesses signed. Why do I have to do that? This because I have to take this date now and put it where? Where must I take this date? Neo, no, this is not an affidavit. This is a power of attorney. The requirements of the power of attorney is signed in front of 2 competent witnesses by the transferor. This is not an affidavit, not needed for commissioning. When do we deal with affidavits? Under certain applications, sundry applications, such as your regulation 68, then we would require the application to be dealt with as an affidavit. But we get to that. Those are really sundry applications. Those applications are money for jam. That's an easy 20 marks. If you get them, you smile all the way to the bank, really. They are, when I say money for jam, I mean it's marks for free in your exam. That date, a couple of people have now answered, and you're right. You take this date and you put it in the preamble where we say Joe Soap, identity number, unmarried. He authorized the appearer, okay, by virtue of power of attorney to pass transfer, and right below I say issued to him by Joe Soap, identity number, unmarried. I say dated at Durban on the 15th of July 2018. Okay, Igla says the date is what appears on the deed of transfer preamble. That is correct. If there are encumbering, I just want to read this. Carla says, if there are encumbering conditions, then paragraph 3 wording would change. The only situation where you would cite encumbering conditions, okay, or refer to encumbering conditions would be if you create them, because you can't pass transfer if your land is encumbered without dealing with the encumbrance. That means I don't necessarily cite them there, I just lodge a consent. For instance, there are certain deeds that say the transferor is not allowed to transfer to sell or alienate the property within 20 years. Okay, these are normally in favor of the municipality, etc. Okay, now how do I deal with that? I get the Department of Housing to consent to the sale. Okay, so then I lodge the consent. So those, otherwise I can never deal with an encumbrance. And what is an encumbrance? I've pledged or I've mortgaged it. And I've just told you minutes ago, is when we do bonds in full, you will realize that you can only cancel, substitute the parties and replace them or the property. Otherwise you cancel that bond. You cannot do that. Okay. Does it? Okay. Slow down. I can't read that fast. Lilani is asking, does it go to the preamble and is removed? You guys are too fast. Is removed from the bottom of the PA, or does it also stay on the PA? What? Lilani just explained to me that one. It says, does it go to the preamble and is removed from?
Yes, I'm like, sorry, I just want to explain quickly. When we were talking about the date at the bottom, yeah, I just wanted to understand, does the date that you move to the preamble, do you move it so you remove it from the bottom of this power of attorney?
No.
And it goes to the preamble, or do you leave it there and just also add it to the preamble?
You leave it there and you use it in your preamble.
Okay, sorry, I should have explained that a little bit better, but
No, it's fine. The thing is, when you lodge your documents, they check that date and they want to see that, again, you are consequent in what you do. You understand that that date has to be in my preamble, because if the date differs, it's a rejection note.
Okay, all right, thank you. I understand now.
Then you don't have authority, you see. So there's a couple of things that they check. If you put in here that the property is R1 million, you can't put in the in the deed that the consideration is only 200,000 rand. You can't. If you are dealing with the declared value, and this is all part of transfer duty, certain situations with declared value, deemed value, etc. So I'm referring to a couple of things we're getting back to a bit later. Declared value in estate transfers, etc. Then I would refer to the deemed value or the declared value, and not the consideration. Okay, but we're going to get to those little things, those nuances. Okay. You really gave me a throat now. I hope nobody's ears burst to that shout, but yeah. So the power of attorney would always have a consideration. It normally would. Okay. Consequence here is, unless if we deal with the donation, we would still declare the value to be XYZ. Lilani, you really gave me one there. You guys don't understand. I'm looking into a void. I hear nothing. So if one of you speak up, I literally, yeah. Anyway, if I'm dealing with certain transactions, I still have to deal with the deemed value, because that, again, that deemed or declared value goes into my deed, and it goes into my transfer duty receipt, everything, you see. And when they examine the deed, then they check your power of attorney. Does it compare to what you are saying to the receiver of revenue is the declared value of the property? Because that has to be the same as is disclosed in your deed, because the deeds office also needs to say, okay, I'm calculating the registration fee based on the value of R1 million, for instance. Igler asked, in the exam, do we always have to draft the power of attorney with the deed of transfer, or we may be asked to draft either? It may be that you are asked to draft either or, but that's important that you understand that you read your question and identify, are they asking me to draft all documents that has to be lodged in order to effect transfer, because then I have to know, I have to draw the power of attorney and I have to draw the deed. That's the minimum things I'm going to draw as prepare, draft. That's going to be the minimum documents that I would have to draft and prepare, okay, for lodgement. They will never tell you to prepare a transfer duty or a receipt or prepare a rates clearance certificate, but they may say to you all the documents that has to be prepared and drafted you must do, and then maybe there's an error that you have to correct, so you have to maybe prepare an application in terms of section 4 subsection 1 subsection B of the DRA, where you first have to correct the error in the holding deed and then go on to preparing your power of attorney and preparing your draft deed. Okay, so those things you must be able to identify. All very good questions. Okay, so always remember be very consequent in your actions. If you prepare stuff, you can't have, I signed it at Durban the 15th of day of July, and then in my deed, I just have a completely different down and a completely different date. Okay, so important. We are already over time. It's already 25 to 9. So is there any question? This is a mouthful for tonight. A lot of law that has to be studied up. So we've done chapter 3 and 4 to an extent. Now we're going on to the citations and the causas and the power of attorney, how we cite compared to all the other situations. Okay, vesting clause, divesting, preamble, causas, very important. Okay, so if there's any questions that you wish to ask, if I haven't posted, Sarah, I'm going to be back with you just now. If I haven't posted before I go, before 10 o'clock this evening, if I haven't posted on the WhatsApp group the Chief Registrar circulars, including the one that I didn't get to tonight, but I did show you the one for civil unions. I will upload that one as well. Then just give me a nice, gentle nudge to remind me. Okay. Sarah, you have a question?
It's not relating to the lecture today. However, I'm just concerned. I haven't got my feedback regarding the pre-assignment.
Were you in the lecture where I dealt with the pre-assignment, pre-assessment?
Yes, but I had the problem with my internet. So, okay. But I did, yes. For the entire class, I was out of it.
Okay, send it to me, and then because when a lot of people, and this is the thing, if you are diligent and you send it to me immediately when I give a task, then I immediately am able to give you feedback. But
you know what, Marika, I send it on the, sorry to interrupt you, I send it on the e-leader as well as your email. So I don't know, because it appeared on the, it appeared on the date of the assignment that is due for September.
Oh, okay. Yeah, because I uploaded them for everybody's interest. So I will give you separate feedback. It's not a problem.
Okay, thank you so much.
Just send it to me again, because I have so many emails in my inbox.
Must I send it to the email again?
Yeah, please do, because I don't know, I might have saved it somewhere, so it will save me time to look for it.
Okay, thank you so much. I'm getting out now. Thank you.
Okay, thank you.
Thank you. Bye.
See, Alan has, bye-bye. Alan has also gone. Just a note. Thank you for the guys that say thank you. That's nice. I appreciate that. We don't say thank you enough, I don't think. So I'll if there's any questions, it doesn't look like anybody has questions. You have a lot of work to go back to, and I'm going to give you an interesting question to prepare. Okay. So we've already dropped to less than 40 people. I get it. Today was a difficult day, so yep, it can end now. It's really fine. We're now at about just over 30 people still on the chat. So I'm just going to wait until we've only got about 10, and then I'll also sign off just in case somebody has a quick question. Benedict guest, thanks, but still waiting to be added. Okay, if you ask me, I'll add you. Thank you, everybody. We are around 6 plus the tokens I can see, or the appearances I can see, which means we are under 20. So goes on section and regulations. Okay, I'm glad. Yeah, you have to know all of those things. Thank you for everybody that did. So just to recap, all CRCs need to be studied. Yes, they do. Specifically the ones that I refer you to. Okay, but you can't study this whole book. Okay, so just the ones that I refer you to. Thank you everybody for being so interactive. We are under 10 now, or 15 now, so I'm going to allow you all to go, and then we come back on fresh on Saturday. Have a good evening. Goodbye.